on Nwokocha Ayu. Now, according to the PDP constitution, the NEC, which is the second highest organ of the opposition party after the National Convention, is supposed to meet at least once in every 3 months. And then the Sun newspaper went ahead to quote the PDP constitution, Article 31, subsection 4, as amended in 2017, and it goes on and on. It also talked about a top party source who told Daily Sun that acting national chairman Umar Damagam, whose duty is to convene a NEC meeting, is afraid to do so because of the likely outcome. So, is this the division that the 27 lawmakers who defected referred to or made reference to? Is this weighty enough when you look at what the Supreme Court has said? Prof, this is where you come in. What do you make of this? Does this give legal backing to the defection of the 27 lawmakers?
It's indeed interesting, and tending towards a crisis.
Okay.
So the best of my understanding, from what you have read, really, not just my understanding, from what you have read, there seems to be a developing disagreement over which camp will produce the next set of officers.
Okay.
And if that is the case, it means you still have a valid set of officers that are operating the PDP today. That being the case, there is no division at the national level of the party. There is an ESCO that is functional. There is a board of trustees that is functional. If we go by the words of the Supreme Court in the case I mentioned in our earlier discussions, where the court specifically outlined what amounts to disagreement or division at the national level of a party in a party. While you have a functional ESCO, you have a functional board of trustees, and there is disagreement over which camp will produce the next officers. There is no crisis. There is no crisis. And then, secondly, if we are crisis to even develop now, that will justify, we are the party to be divided now at the national level into 2 or more actions. That will justify any action taken with effect from after that division has taken place, but will not justify an action before. If you look at the language of Section 1091G, it did not say provided the defection is not informed by an anticipated crisis in a party. So
they can argue that, due to the happenings,
the action of over a month ago, or about a month ago.
Okay.
That was taken while there was no crisis in the party. It will justify anyone that is taken after the crisis has developed. Anticipation of crisis will not be, it's not a ground for defection. It is the existence of a crisis of the nature that the Supreme Court explained and described in the judgment that is defection, that is justification of defection.
Okay. Now, let's look at the issues one by one. Now, a party or the PDP, according to its constitution, is supposed to hold NEC meetings every 3 months. Its inability to hold that meeting for about 16 months, is that not an indication to a party that that is failing, or that has failed because it's not meeting its constitution?
To hold that meeting for 15 months did not prevent them from generating candidates and contesting the election of 2023.
Yeah,
it did not. So the party is functional. Fully functional.
No. I think when they generated the candidates was I think the last time that they had. So 12 months last year, then 4 months from the previous. So you see, the question is, since that time they've not been able to hold, a NEC meeting. There is also the fear that if they do hold a meeting, that the fight will be so disastrous that
that is speculation.
Okay.
Are they functioning? Answer is yes. they have their organs as a political party as defined by the Constitution? The answer is yes.
Okay.
Do they have necessary officers? The answer is yes. Do they have a board of trustees? The answer is yes. Are there a rival board of trustees? No. Is there a rival next? No. So, when we say there is division, where is one faction? Where is the other faction?
Okay, talking about faction, having two persons running for national secretary or claiming to be national secretary, is that faction enough? Because that's even where the 27 lawmakers focused on in their reason for defecting. Is that enough?
That the report you read says they are jostling over who will take over.
No. One side is still in support of the embattled national secretary. Another is looking at replacing, substituting the embattled national secretary.
Let's say, for instance, that the national secretary of a political party dies. Does the party cease to exist?
No,
it has not.
Yeah.
So the fact that there is a dispute over one officer, but which has not divided the party into factions that you can identify. There are no rival institutions or organs of the political party that you will now focus, okay, there is a division in the party, there is this faction, there is that faction, this is the one I support, this is the one I don't support. If the one you support merges with another political party, you can retain your seat because there has been a merger between your faction of the party and another party. But are there rival necks? Are there rival board of trustees? Are there rival officers of the party? Because if the death of the secretary will not cause the party to stop functioning, dispute over who is the secretary will not mean that the party has stopped functioning or has become divided in the manner that the Supreme Court described.
Okay, so even though there are all of these cracks are not enough to argue in court that there is a division in the party.
There has to be division. These cracks exist in every party. Remember that it's political party and it's about political interest. In every circumstance in which you have contestations, you have factions or you have parties, interest groups that are seeking to take the representation. That in itself, the existence of that is not a crisis. That is not. That is indeed the act of partying, political partying. There must be people who are interested in representing the party in holding offices and all that. And in every congress, every convention, etc., that is what those things are about. It's about competing interests and the one that will be chosen by the party.
Okay.
So that in itself does not describe crisis. The Supreme Court was particular. It has to be balkanization of the party. Balkanization is not interest groups behind that are struggling for their representative or their interest to win existing seats. It says balkanization means that the party neck is divided. You have factions of the party neck, and the party therefore cannot speak as a party as defined or described under the Constitution. Or the board is divided. And people support one faction, the other support the other faction, and all of that. Do we have that? Look, there is one neck, there is one board.
Okay, so let's go now. Let's look at the executive. The chairman is in acting capacity because, of course, there was the Nwokocha you must go. That's where the problem started from. Then the next big position, which is the secretary, the national secretary, also is a cause for contention. Maybe the board of trustees are still, I don't know how to put it, but then when you look at the board of trustees, I hear Nwokocha is a member and he's at odds with some people there. When you also look at some other people in that executive, they're not so much in a happy place. Can all of this once again constitute a division in the party? Because it looks like factions, even if it's not clearly spelled out.
As I said earlier, political party is about interest.
Yes, true.
are no longer guessing. We are no longer thinking of what if. We are strictly now guided by the pronouncement of the highest court of the land. There will be factions. If there are people claiming to be the board, these things on the board, the question is, does the party have a board? Your answer was yes. And you say among the board members, there are those who are not happy with the others. But are there two boards? The answer is no. Is the board factionalized such that the board cannot meet should it want to meet? Answer is no. We do not have that report or that development. That has not occurred. The same thing for the Met. So going strictly, not what I think, but going by the decision the Supreme Court gave and the description it gave to drive home what it was saying.
All right, Prof, we have a commercial. Let me pause you now. We have a commercial. Okay. When we come back, we continue. Right. Yeah.
Hurry! It's our season of promotional sales, and you're invited to engage in our anniversary sales and Ember Month's discount.
Again, Prof, welcome back on the show.
Thank you, sir.
All right, so we were, trying to see if there is any way, the reported crisis in the PDP can be used as an excuse by the 27 lawmakers, to back their reason for defecting. Okay, so Prof, you were trying to explain to me that irrespective of the divide, in terms of I'm supporting Nyesom Wike, I'm supporting Abubakar or Atiku Abubakar, I'm talking of the Board of Trustees, or even, when you come to the National Working Committee, there are talks that the acting chairman cannot stay beyond a certain period of time, and the national secretary is currently in a very, big political fight to keep his position. Some people want him out, some people want him, to stay. So when you look at all of it, there is the fight for the control of the party, and you have said, according to the Supreme Court judgment, there is, that's not enough to be seen as a division. But I mean, different factions, even if it's not official, need not be argued in court. If you were the lawyer, would you not find a way to argue that in court?
Well, if we go by the explanation that the Supreme Court painstakingly made in the case, the Ondo State case, simple test is there a political party, existing political party, in the manner anticipated prescribed by the Constitution? If the answer is yes, then there is a party that sponsored you, and you cannot leave that party without consequence. But if the answer is, there is something, but the character of the thing is such that it no longer meets the prescription of the Constitution, you cannot say that there is a party with an incorporated board and functional organs. If you cannot identify that, then there is a crisis, and it is questionable whether your party still exists, and you can take the action, and you will be protected under the proviso to Section 109 of PDP.
All right.
So, if you ask those questions, is there a PDP board? I'm sure the answer is yes. Who are the members? I'm sure you can identify specific members.
Of course.
Those people you will identify will not be different from the people that another person will identify. If you ask, meaning that on record, and indeed, there is a PDP board. Do they like each other? That is a different question. Answer will be no. That's a different question.
Okay.
That does not touch on the political party and the existence of the board. And I'm sure it's the same thing at the next level. They may even disagree with decisions of the party or of the board and go to court. That is not evidence of crisis. That is a legitimate way of expressing dissent in an organization you belong to, where you do not agree with their decision. So, can we, in any sense, say that PDP has ceased to exist in the manner contemplated by the Constitution? I'm sure the answer is no. Okay.
All right. Let's take some reactions to our conversation. We'll start with WhatsApp now. Lady V sent in a message and says, Kalada, stop your conny questions. She said. The Prof has explained this over and over to the understanding of the common man. However, you scratch, you can't find what you are looking for. We, the listeners, know where you're toying to. I don't get that part. But he said the law is explicit. Please don't try giving them hope out. I don't get that part, but you said simple out. Lady V, I'm not trying to give anybody. I'm just trying to think like the politicians are thinking right now, and that's why we're having the conversation.
I'm playing the developer.
Maybe you can say that, Prof. Maybe you can say that. But I'm just trying to think how they're thinking and looking at that report. The report is saying there is a crisis. And who knows, maybe that could be used as an excuse tomorrow or as a reason. And so we're looking at it from the legal angle. And that's why the Prof is here. And the Prof is, telling us what is the law and what the law says. So it's not about my opinion. It's about the Constitution. And I'm just going to ask the questions. even if it means, double checking and triple checking. But this one says, hello, Mr. Kalada and Professor Nwokocha. In 2013, ahead of the PDP National Convention, the then PDP National Secretary, Brigadier General Olagunshoye Oyinyola, and others held a parallel convention and elected the national chairman. They were later christened the new PDP or NPDP. This was the prelude for the defection of Senator Magnus Abe, Senator Wilson Ake, and the 27 Rivers Assemblymen. Please ask Prof if this was a good Okay. He said, please ask Prof if this was a good example of how division in the party plays out at the national level. Can he confirm if that 2015 Ondo lawmaker who lost his seat, if it was the Labour Party he left that initiated the case, or it was the rep speaker who declared his seat vacant? Text from Oyibo is asking. I do not know about the Ondo lawmaker, but I do know about the NPDP. He's asking if that is a good example of division in the party.
Okay. Yes. The NPDP, that's a new PDP, was a good example of what the Constitution was talking about. Because if you look at that proviso, it says, provided the defection is not as a result of division in the party or merger of their political party with another, with merger of their political party or a faction of their political party with another political party that they are defecting to. So the new PDP presents a beautiful example of what the Supreme Court was describing. Where you have rival boards, rival necks. This one saying this is what you're saying, this saying that's what you're saying. At the end of the day, one of the factions with a new name, new PDP, moved and merged with other political parties to form the APC. That corresponded with Section 109.1G. So that was a perfect example. Now, beyond those cases, he was asking, was initiated by the lawmaker whose office was declared vacant, a Labour Party member who defected to APC.
Okay.
His position was declared vacant.
By the speaker?
By the speaker.
Okay.
So he went to court to urge the court to hold that he's not supposed to lose his seat because of the circumstances of his defection. I think they had internal state problem within their state and all that. And the Supreme Court said no. So the matter dragged on up to the Supreme Court. And the Supreme Court affirmed the decisions of the lower court. So they said that there is no crisis in the party as anticipated by the Constitution. And then the Supreme Court went on to give that clear indication and explanation of what crisis in a party means. But it does not include crisis in the state, because you are not sponsored by your party in your state. You are sponsored by your party, which is a national body. Your state is only a branch. So that is the case. The man whose seat was declared vacant sought to be reinstated, and he failed.
Okay.
So whether it is even the party, whether it is the Labour Party that goes to court, or the man himself went to restore himself, any of the circumstances, anybody who goes to court, the question to answer is the justification given by the Constitution existing in this particular case. If the answer is yes, it's okay. If the answer is no, too bad.
All right. And
because they confirm that he has vacated his seat.
Victor,
the question is, has he vacated, not should he vacate?
Okay.
The court confirmed that he vacated.
Okay. Victor is asking the question, please ask Prof, should there be factions in the PDP in the coming months? Can it serve as justification for the defection of the former lawmakers? I think I asked that question already, but Victor is asking again.
Yeah, and I answered that anticipatory crisis is not a ground.
Okay.
Anticipated crisis is not a ground. It is an existing crisis that is a ground for defection.
So even if they decide to fight today, it will not help the cause.
No, it will not affect the action of last month.
Okay.
And decide in the court to decide based on the facts of the party at the time they took the action in question.
But now that you've mentioned, you mentioned something. You said it's not about whether the court would not ask if he has vacated. It would already have happened before the court will come into place. But there is the conversation about the court orders in Rivers State, and how there is the talk about the 27 cannot vacate their seats because of the interim order. Can you expatiate on that, or can you explain that for us?
When a matter comes before a court, and a prayer is made before the court by one of the parties, which is an SPA application, meaning that the other party is not present. It's usually an application made to preserve the condition so that things will not go beyond remedy. If irremediable harm will not be done. If an application is brought before the court to preserve the circumstances pending when the court will hear the matter so that irremediable damage will not be done, the court can grant such order. That order is called an interim order. It's a temporary order that is made to last until the court has the opportunity of hearing the motion on notice, which is the same prayer. This time served on the other party so that that party can respond before the court can rule. So an interim order is made for that purpose, pending the hearing of the motion on notice. And then when the motion on notice is heard, it will enable the court to give a ruling that will extend the determination of the suit. So, again, in law, orders, injunctive orders, are made to restrain an action that is about to take place, an anticipated action, or an action that is in process and has not been done. So you stop it from being done. However, if you look at the date of the ruling, I think the ruling that was in the media before it was officially confirmed to be a ruling that was presented as a leaked judgment came after the action has been taken.
That's for the vacation process.
Yes. Yeah, the one restraining
INEC.
the assembly and INEC from conducting elections. Yes, it can effectively restrain INEC pending the hearing of the application before the court, because INEC has not taken its action. But for the action of the House of Assembly in compliance with subsection 2 of section 109, that has already been done, and it cannot restrain a completed act. So the status quo at the time that the court is maintaining is the status quo after that time, and that is that the seat has been declared vacant, and the court in Abuja cannot sit on appeal over even interim order made by the court in Port Harcourt, because they are courts of equal jurisdiction.
All right, Prof, I would have to let you go. There's a paid program up next, and I have so many other questions, but time is not our friend today. All right, thank you very much for your time and your contribution once again.
Always a citizen. Thanks for having me.
All right, thank you very much. Professor Ritchard Nwokocha, Professor of Law, Rivers State University. We'll continue this conversation after the 6 p.m. news. Do stay tuned.